Hello everyone, welcome. This is another in the 10-minute tip series of recorded programs for credit and collection professionals. This one is titled Preferences in Bankruptcy. My name is Michael Dennis. Let's go ahead and jump in. What is a preference claim? Well, under U.S. bankruptcy law, and at its most basic, bankruptcy preference claim is a claim that is typically filed by the bankruptcy trustee against a creditor company in a business bankruptcy case. In that preference claim, an assertion will be made that the creditor company was paid money by the bankrupt customer within a specified period of time prior to the date of the bankruptcy filing. In the preference claim that the creditor will receive in the mail, the document will indicate the amount that it is claimed that the creditor received unlawfully or unjustly, perhaps is a better word, that must be repaid to the debtor company. The preference claim, or if you prefer, the preference demand notice, the document will usually indicate that the creditor must immediately repay the money that it received based on the claim submitted about a preferential transfer. Under the United States Bankruptcy Code, a payment that we receive as a creditor company from a customer may be considered to be what is referred to as an avoidable preferential transfer if certain conditions are met. The first condition is this: there was a transfer of the debtor's assets, as would be the case when a payment is made by a customer to a creditor. And two, the transfer was made for the benefit of a creditor against an outstanding indebtedness owed by the debtor, which again would be the case if the customer was paying an invoice that was due or past due. Condition number 3. The payment may be considered an avoidable preferential transfer if the payment was made within 90 days of the date of the debtor's bankruptcy filing, or 1 year for payment to an insider. And number 4, provided that the payment that we received as a creditor was made when the debtor was insolvent. And number 5, provided that the payment enabled the creditor to receive more money than it otherwise would have received if the customer in question had filed for a Chapter 7 liquidation bankruptcy. So what happens is we receive a notice in the mail from the trustee in connection with the bankruptcy that says you need to return this money to the debtor because it is an avoidable preferential transfer. Well, what happens if we ignore the request, ignore the demand, ignore the claim? Well, the bankruptcy code permits a bankrupt customer or a trustee to sue creditors to recover payments made by the debtor company now in bankruptcy during that short period of time prior to the date that the bankruptcy was filed. And unfortunately, this often comes as a very unpleasant surprise to trade creditors. They're happily going about their day. They're aware potentially that a customer of theirs has filed for bankruptcy protection. And then at some point, they open up the mail and there's a legal notice from a trustee that says, you must return immediately this amount of money, which you received in the 90-day look-back period prior to the date of the customer's bankruptcy filing. If you receive one of these notices, please consult with your attorney. Why should you consult with your attorney? Well, because this is a complicated legal issue that will require the expertise of an attorney. What you and your attorney will discuss and agree upon at some point is what options and alternatives you have with regard to potentially not repaying the preference claim that you've received. Whatever defenses you have against this demand that you return the money will need to be raised through your attorney. And none of your options and alternatives and defenses are necessarily obvious to credit professionals. What this means in a very real sense is what you don't know about U.S. bankruptcy law, and specifically what you don't know about the U.S. Bankruptcy Code's rules governing preferential transfers, can hurt you and your company financially. At this point, you might be asking yourself this question: I've heard the bad news, Michael. Is there any good news? And the answer is possibly. So it turns out that even if the payments that you received during the look back period, that 90-day period we were talking about, do in fact meet the requirements for preferential payments, your company as the creditor may still be able to avoid having to disgorge or refund that money to the bankrupt customer. How? Well, fundamentally through your attorney, but essentially, there are several defenses to a preference claim that you've received, but the creditor company has the burden of proof. They must show that the requirements of the defense against having to disgorge the payment they received have been met, and they have to demonstrate that the requirements have been met to the satisfaction of the bankruptcy court, of the bankruptcy judge. So 3 of the best known defenses available to trade creditors in connection with preference claims or demands that we disgorge payment to a bankrupt customer are listed here. There is the contemporaneous exchange for new value defense. There is an ordinary course of business defense. And there is also a statute of limitations defense. It is beyond the scope of what I can do in 10 minutes to even attempt to describe in any worthwhile detail the requirements in connection with any of these 3 defenses. Suffice to say that we will need legal expertise. We will need to involve an attorney in order to assert one of these defenses, and the court will evaluate our assertion that there is a defense based on the facts that we are able to provide. So again, it's up to the creditor to provide an affirmative defense to the court demonstrating that they do not have to return, disgorge, remit the payment that's claimed in by the customer, by the debtor, in the preference demand. Well, thank you for sticking with me. I know this is a complicated topic and not intuitive in any way. I do hope that you found this presentation to be interesting or helpful. To learn more, please consider listening to the entire 1-hour on-demand program about U.S. bankruptcy laws and how they affect a credit department. For information about that program and other on-demand programs in the program library, please contact my sponsor, the Wisconsin Credit Association. Thanks a lot. Have a great day. Bye.